Good morning, good afternoon, everyone. Welcome to Deloitte's Debrief webcast series in Asia Pacific. Our webcast today is from our Geography Updates series and is titled Supreme Court Ruling on Hyatt, covering permanent establishment implications and related profit attribution. My name is Vineet Chabra and I'm partner based out of Deloitte, India. I have the pleasure of hosting today's webcast. I have, along with me today, Jimit Devani, Manmeet Vij, and Sanidhi Shah. Jimit is a corporate tax partner and working with Deloitte India. Manmeet is a transfer pricing partner with Deloitte India. And Sanidhi is corporate tax manager and working with us at Deloitte India. You may access our bios on the left side of the screen. Before I introduce the agenda for today's webcast, I would like to take a moment to highlight some of the features of our webcast console. First, all users are on listen-only mode. If you have any content-related questions, you can submit at any time in the Q&A box at the bottom right of the screen. We will do our best to respond to your questions during the presentation. Second, all PC users can maximize or minimize each box at your convenience during the webcast. You may also explore the icons at the bottom of the screen. If you want to download today's slide and related publications, please go to the download and links box. On the other hand, mobile device users can view the slides and answer the survey on the screen. Thirdly, if you require an attendance record for this event, you will receive an automated email with CPE certificate after watching for 50 minutes. Now let me move to the topic we are going to discuss today. At the outset, I would like to share that the Honorable Supreme Court judgment in Hyatt International Southwest Asia Limited has sparked a significant debate on India's evolving judicial stance regarding permanent establishment under tax treaties and the methodologies for profit attribution to such PEs. As my colleagues walk you through the slides today, you will gain insights into the nuances behind the Supreme Court's reasoning, why and how it concluded that Hyatt, a foreign enterprise purportedly providing advisory services to domestic entities in India, was effectively engaged in carrying on the business of the service recipient. The team here will present the key facts and findings of this ruling and highlight its practical implications for global multinational managing cross-border service structures involving India. With this, let me hand it over to my colleagues, Jimit and Sanidhi, to walk you through Hyatt ruling. Over to you, Jimit.
Thank you, Vineet. Before we go into the decision of Hyatt case of facts of the case, let's understand the concept of a permanent establishment and when does it come into picture. Today, when a foreign company can, of course, do business in India in various manners. It can also set up a shop in India by way of a subsidiary or a limited liability partnership, or can also do businesses through branches, through agents, through rendering of services, etc. So that is why if India as a source state wants to tax the foreign company in India on its profit, then according to the double taxation avoidance agreement signed by India with various treaties, and this is common across the world, India will have the right to tax only and only if the foreign company who is earning business income, India will have the right to tax only and only if the foreign company has a permanent establishment in India. Depending on how the foreign company carries on business in India, whether through an agent, then an agency P will come into picture. If it is rendering services, possibly Service P will also come into picture, and also a fixed base P will come into picture. And that is why, depending on the business models of the foreign company, the relevant P will come into picture, and that needs to be analyzed before India gets the right to tax such foreign company in India. In this case, which is Hyatt, the facts, of course, Sunny will discuss in brief. The key concept which was discussed was on the fixed base P, and little bit it was also interplayed or intermixed with service P. The relevant treaty was India UAE double taxation avoidance agreement, and there was some uniqueness to this treaty as well, and we'll come to that. Article 5.1 of the India UAE tax treaty, and majority of the treaties which India has signed would have a similar language, that the permanent establishment would mean a fixed place to which a business of the enterprise means the foreign company, is wholly or partly carried on in India. That would be typical Article 5.1. And Article 5.2, which is basically extends the 5.1 thing, is basically if you have a place of management in India, a branch in India, or an office factory, then India will have the right to tax the foreign company in India. Apart from that, there was a clause on service P, basically that when a foreign company renders services in India, which are consultancy services, either through employees or through any other personnel, that means their subcontractors, if any, provided that activities continues for a period of more than 9 months in any 12-month period, then you will also possibly have a service P. But that's a service P. Fixed base P is anyway independent. And this decision of Hyatt focused on actually also a fixed base P. So while the sentence is only one, fixed base place of business through which business is carried on, typically when we understand the concept of fixed base P, and Soumya, if you can move to the next slide, there are typically 4 tests to be satisfied, and these tests are laid down in the OECD commentary, UN model commentary, as well as various judicial precedents. That's how it is typically understood. And what are the 4 tests? The first test is that the foreign company should have a place of business in India. Okay. Now, of course, that place of business, what do you mean by place of business? Whether you need to own that place? No, you don't need to necessarily own that place. Even if it is on lease, that is good enough for at least satisfying the place of business. You don't need to satisfy the ownership criteria. It can be even a rented premises. Even if you're using a business facility of another enterprise, that is also possibly a place of business. Then once you have a place of business, what is the second test? The second test is, okay, this place which is available should be available to you for a particular period of time. That means a permanence test. Someone also calls that as duration test. There are no specific guidelines. Even in an OECD commentary, there was a reference that generally when a foreign company carries on business in another source state, that is in case of India, generally if you carry on business in India for more than 6 months, then you certainly would have a PE. However, it also states, the OECD also states, it depends on the nature of business of each foreign company. And that is why this 6 months is not sacrosanct. So even if you have a presence in India for less than 6 months, and if your nature of business is such that you're not required to stay in India for a particular period of time, which is more than 6 months, then also you could possibly have a permanent establishment in India, or you may possibly satisfy the permanence test in that case. Okay. So that the Honorable Supreme Court also relied on the another Honorable Supreme Court decision in case of Formula One, where practically it was the Formula One in India was practically only for 3 weeks, 1 week prior to the race, 1 week during the race, and 1 week after the race. Still, they said that no, sorry, you will satisfy the permanence test because they didn't see only that 6 months criteria. They said that your nature of business was such that you were required to be in India only for that period. Plus, that place was under your control, and we'll come to that. And your contract was actually for a period of 5 years, which were extended. Reference has been made to this judicial precedent also in Hyatt, because that's how the permanence test has been satisfied in this case also. So having a place of business, which is where you satisfy the permanence test, is that which is fixed for a particular period of time has to be under your control, or you need to satisfy the disposal test, as we say. Now, what do you mean by control is, of course, a subjective interpretation. And that's where this decision, the Honorable Supreme Court has laid down very good principles as to how do you determine control. When can you say that the foreign company is practically controlling the operations of the Indian company? And that's where you will satisfy the place of disposal test. So once you have a place of business which is fixed, you satisfy that disposal test. That means you have that under your control. It is also important that the foreign company carries on business from that place. So even if you satisfy the first 3 tests, but if you don't satisfy the 4th test, that is business activity test, you will still not satisfy the test of PE, and you may possibly not have a PE. That is why it is important that all the 4 tests are cumulatively satisfied. What is the business activity test? That the foreign company needs to carry on business activity in India. Okay? There has to be revenue operations which the foreign company needs to carry on in India. And that's where typically, in some of the other forms of business, for example, a liaison office, we see that you don't satisfy the business activity test. And that is why in such cases, unless you cross the line, you generally do not constitute a permanent establishment. So in a nutshell, if a foreign company satisfy all these 4 tests, which is very, very subjective, then they would have a permanent establishment in India. And in that case, India will have the right to tax it. And we will also touch upon typically what kind of business models could be attracted. But now, coming to the facts of the case, I would want my colleague Sanidhi will brief us on the facts of the Hyatt case, and then we will discuss how does it, how did it conclude. Over to you, Sanidhi.
Thank you, Jimit. So why we are looking at the facts of this case first is because this is a very fact-oriented case law. Both the High Court and the Supreme Court in this ruling have based their observations based on the facts. So it's very important that we understand the facts in detail before we move on to the observations. So if you look at the diagram on our left, we have an entity in UAE, which is called as Hyatt International Southwest Asia Limited, or I will refer to that as Hyatt. It is an entity which is a tax resident of UAE. Hyatt has entered into 2 strategic oversight service agreement, or as we call as SOSA, with an Indian entity, which is Asian Hotels Limited, or AHL. AHL runs 2 hotels in India, one in Mumbai and one in Delhi. At the same time, AHL has also entered into a hotel operating service agreement, or HOSA, with Hyatt India. So we have 2 agreements which are running in parallel. One is the SOSA with the UAE entity, and one is the HOSA with the Indian entity. Now, what does SOSA involve? At the outset, we need to understand that this is not a short-term arrangement. The term of the SOSA is for 20 years, and it is further extended by another 10 years by way of mutual agreement. So overall, we are looking at a 30-year horizon. Permanency, as Jimit discussed, is one of the key tests in determining a permanent establishment. And with the 30-year criteria of this SOSA, this permanency test may be satisfied. Under the SOSA, Hyatt commits to deliver strategic planning services and know-how for developing and managing a high-quality, fully functioning hotel in India. The agreement mandates that the hotel operations must align with the Hyatt operating standards, which is coming from the HOSA. Hyatt provides strategic plans, policies, guidelines, even parameters for operating the hotel in a manner which is consistent to Hyatt as a global brand. This includes policies pertaining to recruitment, interviewing, and assisting in hiring general manager and any other key personnel. One of the important aspect over here is that even some of the interviews and hiring decisions were also taken outside India by Hyatt UAE. So Hyatt was not just setting the recruitment policy via SOSA, it was actively assisting in hiring non-local key personnel such as the general managers and the executive committee for the Indian hotels. This level of involvement in the recruitment goes far beyond mere advisory. In fact, Hyatt also had the sole discretion to assign some of its employees as a full-time executive to work in India on an occasional basis. Now, when we look at the assessment year in question, the court also observed that during that year, 6 of the Hyatt overseas personnel in India, and they had stayed in India. However, their stay in India was below the 9-month threshold, as is given in Article 5 of the India-UAE Treaty. So on paper, because the 9-month threshold is not breached, the P may not happen because of lack of physical presence. But what the court looked at is whether physical presence is the only test, or do we also need to look at the substance. Now, other policies that the SOSA requires the Asian Hotels Limited to align with are overall purchasing policies for the Indian hotels. Now we know that procurement is one of the most crucial aspects of the hotel operations, right? So by formulating such policy, Hyatt practically governed selection of all the goods and materials, all food, beverages, furnishings, and even policies for guest admittance. The policies also determine the pricing of the services that Hyatt hotels have to operate with, any promotion and marketing services, and even the centralized reservation system by which Hyatt takes on the reservation. As we'll see ahead, the court determined that all of these policies put together are not only something which is auxiliary, but it is the core functioning of the business model of a hotel. So when we look at the SOSA, Hyatt effectively is controlling the most crucial aspects of operating a hotel. Soumya, if you can move to the next slide. Hyatt also reviews plans and specifications for any future alterations on the hotel, which includes replacement of any furniture, any equipment. They even formulate policies which govern the operating bank accounts of the Hyatt hotels. So practically all payments and receipts which are done through the operating bank accounts are also governed by the SOSA policy. SOSA also mandates that AHL cannot use the hotel as a collateral for any debt that they want to take unless they obtain non-disturbance and attornment agreement, which are clauses which are acceptable to Hyatt UAE. This clause shows how deep Hyatt UAE's involvement is with the strategic and the financial decisions of the Indian hotel. And lastly, for rendering all these services as are mentioned in the SOSA, Hyatt UAE is compensated by way of a strategic fee. Now, how is the strategic fee computed? It is calculated as a percentage of the entire revenue of the Indian hotels. And when I say revenue, I mean the room revenue as well as any other indirect income, such as maybe from the restaurant or any other spa services. So all the revenue of the hotel as a percentage of such revenue and the cumulative gross operating profit of the Indian hotel. This is how the strategic fee of Hyatt UAE is determined. This creates a direct link between Hyatt UAE's income and the Indian hotel's performance, which also is an indicator of the significance of the involvement of Hyatt UAE. So we have seen that Hyatt UAE does have significant level of level of involvement in the hotel operations by way of the SOSA. So now we'll see as to how these facts are looked at by the court and how they have given their view basis that. Back to you, Jimit, for taking us through the High Court and the Supreme Court observations.
Thank you, Saridhi. Now let's look at, on these facts of the case, what did the Honorable High Court and Supreme Court held. The Honorable High Court also adjudicated that there is a permanent establishment of Hyatt in India, because it was also that it was a long-term nature of the agreement. So it was not that you have to just see the 6 months criteria and of that, or the 9 months criteria. You had to see it was a 20-year agreement. There was a permanence and continuity of the business arrangement. This principle was laid down in the, as I said, in Honorable Supreme Court decision of Formula 1. So that case law was relied, and then Honorable Delhi High Court said that no, you have to see that stability, which is there in this case for 20 years. So you satisfy the permanence test. You had the right to assign anybody at your will to the Indian hotel at any point of time. Anybody can visit India, stay in India for a period of time, oversee the entire operations. They can be seconded. You don't need any Indian company's permission, etc. So that means you had practically have full control. And all these things were, of course, done in the name that we are doing this in the name of brand uniformity, or for more as a strategic or compliance of our operational policies. In the name of brand uniformity and operational policies, all these activities were done by the foreign company. Then the High Court also held that you are not only doing practically the hotel operations, you are training the Indian people, controlling the branding, marketing, the entire products, all the day-to-day operations. Okay, when they say day-to-day operations, means practically you will decide what's the menu of the hotel, what's the linen, how the sofa, the bed, everything will look of the hotel. So practically it is you who is deciding ifs and buts and nuts and bolts of the hotel. And that was possibly part of the operational manuals which were there. That means you were practically also being under full control over the hotel premises. And that was the last test also. They said that, you practically were having full exclusive control, while on paper, technically it was under the Indian thing, but otherwise you were exercising all pervasive control. And that is why you satisfy the place of disposal test as well. Now let's look at what was the Honorable Supreme Court held. The Honorable Supreme Court, if you go to the next slide, Soumya, the Honorable Supreme Court, if you again bracket, while Honorable Supreme Court has not laid down this separate brackets of 4 criteria, but I'm just saying if you look at it from a 4 criteria of a fixed place of business, etc. If you see the first, there was a continuous Hyatt staff located in the hotel premises, and there it typically was the first box. If you look at it, there was a fixed place which was actually available for the foreign company at their disposal. The second test was whether you have a permanence test, and there the Honorable Supreme Court also agreed with the Honorable High Court that you have to look at 20 years and not only the 6 months or a 9 months thing of a year. Important point to note that 9 months is for service fee. And as I mentioned earlier, service fee is different from a fixed base fee. That can be separately analyzed. That service fee 9-month criteria under the UAE treaty is different. So you can still go ahead and say that if you have a fixed base fee, that can still sustain. And that's what has actually happened. And there also, the Honorable Supreme Court made a remark just before 9 months, in 8 months or somewhere, they were going back and then coming back again. And this was going on for years, and this practically will be going on for 20 years. So practically you are there in India for a continuous period, which is stable. Once you are there, it's not that you need to be allocated a fixed desk or anything. you can still have a control because you have the right to enter, exit any premises, and there will be a room booked for you, and you will be staying there for a period of almost 7 to 8 months. So that is why you satisfy the permanence test. The third, which is the place of disposal, that means, and that's how the Supreme Court said, that whether you have a control over the core operations. One very, very important point to note, an observation made by the Honorable Supreme Court is, it says that while you were carrying on and controlling your pricing, procurement, branding, marketing, everything, you also appointed and supervised the general manager of the Indian company. And that Indian general manager was reporting to the foreign entity and not the Indian. Although you were the employee of the Indian entity, that person was reporting to the foreign company, and that is why that was one of the factors which they considered, that the foreign company is controlling the Indian company, because the head of the Indian company is practically reporting to the foreign company. Okay, and what do you mean by controlling? Today, if you are an employee of an Indian company, typically your Indian management will decide your remuneration, bonuses, termination, etc. But if you're practically reporting to the foreign company will decide their bonuses, remuneration, termination, etc. So that is why they said that you are actually reporting to, more likely than not, the foreign company will control the Indian company. And that's how this is a very important test, which, or the principle which the Honorable Supreme Court has observed in its judicial when it's pronounced the judgment. And this could potentially also impact various other companies where such reporting lines are also there. Then one more factor which indicated that a foreign company had a control over Indian premises was that practically even today, if your asset is owned by the Indian company, then of course, if I want, it's my asset, I can go and take a loan against it. But for that also, you required approvals from the foreign company. That means foreign companies practically trying to control everything. So that means they said you have a place of disposal that is for a permanent period. You have a fixed place. And the fourth test, which was on the revenue, basically business activity test, they observed that since your revenue, and this is very typical of an hospitality industry where a lot of earnings are dependent on the profitability of the Indian company, they said that because it's a revenue linked compensation, it is the foreign company who is carrying on business in India, because your remuneration is also linked to a revenue. It's like a contingent fee or a revenue-based link compensation, and that is why it's a foreign company who is doing business in India through that hotel. Apart from this four tests, there were very important 2 points which were laid down. The Indian company they argued that it is not the foreign company which is doing these operations or operational manual. It is not done by the Hyatt UAE. It is done by Hyatt India. The operational manuals is done, everything is done by Hyatt India, and the question of taxing foreign company does not arise, because even if you say it's an operational control, it's by Hyatt India and not by Hyatt overseas. And where the Honorable Supreme Court also says, sorry, I will look at practically the substance of the transaction, and in substance, it is actually the foreign company, that is Hyatt UAE, who is controlling the Indian operations. And it's just that you have bifurcated into two parts of Hyatt India and Hyatt overseas. So they said we will always look at, in substance, who is controlling the company of operations of India, and not only the legal form. And that's a very another important principle, which I'm sure will be used in other judicial precedents also. But that's an important principle which is there since years, has been reiterated by the Honorable Supreme Court. They also mentioned about the 9 months thing. As I said, it was in the context of service fee. So again, fixed base fee can override service fee. And they said, okay, we will not look at only that 9 months. We look at it a holistic period, and we look at the substance over form. And the last argument, which possibly, even if you say have a fixed place, you satisfy all the four tests, the foreign company could have come out of the PE thing and they would have said that, okay, we don't have a PE, if there was a non-auxiliary function. That means the foreign company was carrying on any preparatory or auxiliary activity. Here, the Supreme Court says, sorry, you are in the business of hotel operations. So you cannot say that your main core operation is your or management services for your core operation is actually your preparatory or auxiliary activity. It is your core activity. And since it's your core activity, you cannot satisfy the 5(4) exception, and that is why you will not basically be excluded from the PE. You will still constitute the PE if you satisfy the 4 test. Now, having understood this Honorable Supreme Court decision, it's very important. Remember, this is still that you are having a PE. Ultimately, after having a PE, the question is what next? There needs to be an attribution to the PE. Of course, in one of the observations of the in this case in Delhi High Court, there was a paragraph. It states that practically in this case there was an estimation made of 25% of the net of the profits were said that okay, it is adjudicated to the P or basically attributed to the P. On that, at that time the rate was 40%. So indirectly it was held that 10% on gross basis you pay, and practically that was the attribution held. Important point to note, this was under the India UAE treaty where there was no FTS clause, and that is why it was under the P. Basically you went under the Article 7, Article 5 and Article 7, and India would have taxed you only if there was a P of the foreign company. If there are other situations where such arrangements where such management fees are charged, if say tax is already being withheld at 10% on gross basis or 15%, practically we will have to see that whether, while technically you may have a PE risk, whether practically also whether you really run the risk or not run the risk in case of further attribution. But I would leave that discussion on PE, what are the principles of attribution from a transfer pricing perspective. My colleague Manmeet will touch upon it. If we move to the next, till we move on the transfer pricing, let's just check a sense check of where we are. If we move to the polling question, so and where I maybe before I hand over to Manmeet, if you can just type in your answers. If you believe that this decision, because it's an honorable Supreme Court, it's the law of the land, have you already analyzed it? And maybe you think, okay, everything is fine, there's nothing to worry. Or maybe it's yet to analyze, or maybe possibly you have analyzed and come to a conclusion, no, sorry, it will not impact. Or you're maybe not sure about it still. Okay. We will just take 10 seconds before we close the poll. The interesting observations, which is, of course, who have voted is certainly is that there is an impact, and some of, almost 60% of the people have commented that it does impact, but they are yet to analyze the decision, whether how does it apply to their business model. And some or majority, at least 20% are not sure. So if you see, almost 80% of the people are either yet to analyze or you are not sure of the impact. So certainly it makes sense to have a look at it, because this is the law of the land. You will start seeing some action from the assessment proceedings from this year. So you'll have to wait and watch how does it impact the assessments of this year onwards, because the tax officers will also be now aware of this decision, educated about it, and you could get some questions in and around it. Okay. So handing over to Manmeet, that what could be the attribution principles in case there is a permanent establishment of foreign entity in India. Over to you, Manmeet.
Thanks, Jimit, for articulating the facts of the case so well. As you rightly noted, once a P is formed, the focus of the whole conversation then moves to what can be the profit attributed to P, and consequently, what can be the tax liability of the non-resident in a source state. For a deep dive on this matter, it's important to go through the Indian tax and policy framework in relation to the P attribution. The Article 7 and particularly 7, 1, 2, and 4 are the key provisions to reflect on for this. Article 7.2 of the Model Convention talks about the attribution of profit to PE, emphasizing that the profit needs to be attributed to PE as if it was a distinct and a separate enterprise, engaged in same or similar activities, under the same and similar conditions, and dealing wholly independently of the enterprise of which it's a PE. Now, basically, if we reflect on that, it's recommending the separate entity hypothesis, which is also at the heart of the authorized OECD approach adopted for the attribution of profit, and which is advocating the consideration of PE as completely independent of the HO. That would also imply thereby that the profit of the PE could also be seen as independent of the profit or loss at an overall enterprise level, something we will discuss and debate more in the subsequent slides. In addition, if we look at Article 7.4 of the Model Conventions, they allow a state to determine the profit of a PE based on proportionate method. Is that reflecting the total profit of the enterprise and attributing a part of that to a PE in a source state? However, it's important to note that such apportionment approach is permitted where it is customary in a state to do so. So one first has to arrive at a view what's the customary method of profit attribution in a particular jurisdiction. Moreover, the set clause provides that the outcome should still be in line with the outcome of this article, thereby indicating that it would still require the outcome to be aligned with Article 7.2 or a separate entity hypothesis, and it should not lead to an outcome which is entirely different for the taxpayer than what could be perceived under a separate, say, entity hypothesis. Now, shifting focus to the guidance under the Indian domestic tax framework, Circular number 14 by 2001 established that any transaction between a foreign enterprise and its PE is to be governed by TP principle. Again, thereby advocating that transfer pricing was the key framework for attribution of profit. While on the other hand, Rule 10 permits the tax officer to attribute profit to PE based on either a presumptive method, putting in an ad hoc rate of profitability to Indian revenue, or a proportionate method which would generally rely upon the enterprise level profitability and its attribution to the Indian PE. Though again, it's pertinent to note that the Rule 10 also provides that these methods can be applied where the income of the PE cannot be determined with certainty. So given that caveat, the opportunity and the onus can be constituted to be with the taxpayer to support the determination of the profit attributable based on more appropriate or scientific manner, again implying the application of the transfer pricing principle should be the one resorted to for the purpose of putting the case forward. Now, just reflecting on the guidance and intention of the regulators and policymakers. As you may be aware, in 2019, CBDT Constituted Committee released a draft report which preferred a formulary apportionment for PE attribution. Linking it to the overall profitability of the enterprise and then having weight of certain factors like revenue, employees, assets, which indicated a preference towards Rule 10.2, the proportionate method of attribution. Now, it's interesting to note that in the said report, while the proportionate method was being preferred, it was still mentioned that in case of losses, there would be a minimum profitability presumed for the enterprise for the purpose of attribution. So it was, in a way, a hybrid approach which did not accept loss entirely and kept a provision in case of our enterprise level loss. Further, very recently, last month itself, the Consultative Group on Tax Policy, which was formulated by Niti Aayog, also released a paper laying down several proposals for the profit attribution. The said paper acknowledged that the attribution exercise is typically governed by Article 7 of the DTA and the principle of transfer pricing, and simultaneously also noted that the complexities involved in the attribution exercise is leading to differing views between taxpayers and tax authorities, which would travel to the judiciary, and hence it's vital to understand the experience that are derived from various judicial precedences on the PE attribution. Can we move to next slide, please? Similar to the tax framework, the judicial precedence has also been split over the method to be applied for attribution between, say, presumptive method under Rule 10.1, which is basically attributing a certain profit markup on the receipts from India as the profit. Noted in, for example, in case of several travel distribution companies, profit was simply attributed as a percentage of receipts from India. Or in many cases, we noted the proportionate method under the Rule 10.2 being applied, where profit was attributed to the Indian revenue based on the overall enterprise profit. And in some of the cases, this overall profit was further split between the specific functions where the PE was not performing the overall functions in the value chain. So where the PE was, for example, only involved in sales and marketing, then the total enterprise profitability was further split into sales and marketing as a function. Now, several rulings also accepted the profit attribution based on transfer pricing principles, thereby upholding the authorized OECD approach. It's worth emphasizing here that in several cases where the application of Rule 10 was upheld, the taxpayer did not produce any analysis or TP study reflecting how the attribution can be done based on a functional analysis or a detailed value chain view. This again underscores the need of using a detailed analysis to determine the profit attributable to P rather than leaving this attribution exercise open to the proceedings, open to the tax officers, which can then result entirely in an ad hoc allocation of profit. Moving to the next slide, which is on the specific case of the facts. Now, when we look at the Hyatt ruling, during the assessment proceeding, and as Jimit mentioned, the AO-DRP upheld an attribution at the ad hoc of 25% of the gross receipts, again implying an application of Rule 10(1). In its appeal before the tax tribunal, the taxpayer argued against the profit being arbitrarily attributed and in spite of the entity level operating losses. So again, the 10(2) rule, which was more proportionate, could have led to losses in such a scenario. So 10(1) probably was the one which was applied to have certain profitability being taxable. The taxpayer also argued that it has incurred large operating losses, which is also depicted in its audited financial statement, and therefore there is no scenario of a further profit or taxable income being attributed to India P. In its judgment, while upholding the P formation, the tax tribunal accorded an opportunity, it provided an opportunity to the taxpayer to submit the detailed working of apportionment of revenue, losses, etc. on a financial year basis, so that the profit attribution exercise could be finalized, could be determined. Against the said observation of the tribunal, the taxpayer, in its appeal before the High Court Division Bench, also raised the ground that no profit could be attributed given the loss at an enterprise level. And while arguing this, the taxpayer placed reliance upon the erstwhile ruling of the Honorable Delhi High Court in case of Nokia Solutions. In that ruling, it was already held that if enterprise level there is a loss, there is no case of further attributing profit, because if at all something could be attributed, it was only losses of the enterprise. Now, it was also the point of if this principle was upheld in favor of the taxpayer, then the overall matter of existence of a P could be considered academic in nature with no tax liability fastening on the taxpayer. The division bench was not fully aligned with the said proposition, and therefore the contention was referred to the larger bench for their view. The full bench, in its order on the attribution, meticulously articulated the view and held that P should be treated as separate entity, and that the profit and loss attributable to P should not depend upon the enterprise level position. The ruling strongly advocating a separate entity approach, which is also the pivotal theme under transfer pricing. Now, if you look at, for example, a transfer pricing scenario, we would generally tend to analyze a legal entity dehoards the financial outcome at a group level, which may be outcome of several different activities, several different functions, several different strategies. Take an example of a startup. The decision to invest in, say, a large amount of R&D or to do a penetrative pricing may be taken in one location, which may lead to loss for the enterprise. Now, it could be economically challenging to demonstrate that P would not be allocated any additional profit because the key decisions leading to loss were undertaken in a different enterprise. But on the converse, it's also important to acknowledge that this would also open up the argument for the taxpayer that in case of high profitability of the group also, the same cannot be attributed to India only on a proportionate model if India is not involved in strategic functions. So this, in a way, this whole judgment supports a separate entity hypothesis and bifurcates the role for attribution rather than a view or a linkage to the enterprise level outcome. Accordingly, this judgment brings back the focus strongly on the transfer pricing analysis. Now, as explained by Jimit in the earlier section, a key observation leading to the P formation was continuous and substantive control and supervision by the taxpayer over the day-to-day operations of the hotel. It's important to emphasize and reflect that a presumption of control could be generally heightened under an intercompany arrangement, which generally tend to be long-term in nature. In several of the intercompany arrangement, it may also involve a return based on the revenue or profit outcome of the enterprise. Some of the facts which were relied upon in this ruling for the formation of PE. Hence, multinational group would need to be more cautious on the operational control and supervision being exercised in the context of intercompany arrangements, along with the documentation governing the operational relationship and resultant PE attribution risk. In the context of intercompany arrangement, though, one would be comforted by the Morgan Stanley ruling by the Apex Court, which held that where the Indian enterprise is already compensated at arm's length and the analysis covers the functions that are being attributed to PE, no additional profit can further be attributed in the hands of the PE in India. Accordingly, it's going to be vital for the multinationals group to undertake a detailed functional analysis of Indian operation, analyze if there are any additional functional risks beyond the functional profile of Indian group company that could be attributed, and if so, what would be the right amount of profit. With that, I'll hand it over to Jimit to have the concluding remark on the judgment and then also take us through some of the recent development.
Thank you. If you can go to the next slide, Som, and if there is another polling question. With the increasing PE risk, have to reassess the considering the DT principles, and will because ultimately, once you have PE, the question is also how much attribution have you done your FAR analysis? Have you considered all the facts? Have you documented it properly in your documentation, and then computed done your benchmarking? And we'll wait for 10 seconds before we close the poll. We last okay. Okay. So if you look at it today, at least we have a mixed batch, but good amount of people, almost like 50% or 55% of the people are either actively undertaking the attribution or are considering and undertaking the attribution analysis or with this renewed P attribution focus. Okay, thank you everyone. Let's move to the conclusion that having discussed on the principles which were laid down by the Honorable Supreme Court, thank you Manmeet, and on the P attribution principles. To conclude, what you will have to see is today the principles which were laid down is how much control you have over the Indian operations will determine and will be one of the important tests for determining the permanent establishment. As I said, there are 4 tests to be satisfied. All the 4 tests needs to be cumulatively satisfied, but this decision lays down very principles as to how do you determine when there is a control. There is not a straitjacket formula. The 2 most litigated subject in India, one is permanent establishment and second is transfer pricing. For transfer pricing, there is an APA mechanism which has been brought out. On P, there is one more mechanism which they are planning to work out, which we'll just discuss in next 30 seconds. But that's another thing, and that is why when we look at P, there's not a straitjacket answer. The facts of the case becomes very, very important when you determine. Another principle which was reiterated by the Honorable Supreme Court is that merely because you have a loss in the holding company, that doesn't mean that there'll be no profits attributable to the PE. You will still have a profits attributable to the PE. So this is what the Honorable Supreme Court has said. If you ask me which are the companies or the industries or the business model which possibly could be impacted, could be companies where certainly in the same hospitality sector, another companies who are using their brand names like maybe franchisees, because many of them also have a lot of operational control. Could be in the service industries where you also see a lot of reporting lines and a lot of control exercised by the foreign company on the Indian company, and also manufacturing, especially in the contract R&D. wherever the foreign company does exercise lot of operational control over the Indian entity, this decision certainly needs to be look at it. And those companies who are just using a very simple thing that, oh, if it's just returned 6 months and we are 5 months and 5 days will be out of P, they need to relook at their thing as well, their business model as well, and then take a call accordingly. So as I said, this is the law of the land. This will be followed in the assessments, very likely going forward. And now coming to the next question, or the next part, and which will not take more than 5 to 10 minutes, is on the very important update. As I said, since we are discussing on permanent establishment, it's important we discuss this also. If you go to the next slide, the government body, Niti Aayog, which advises the government on the policy matters, realized that, as I said, there are two most litigated subjects in India: permanent establishment and transfer pricing. So they are trying to see that, because there is a lot of uncertainty and litigation in and around PE, let us see if we can try to come out with a policy or recommendation due to which there will be certainty to the foreign company who are investing into India, and hopefully there will be no litigations as well in India. Since there will be certainty and lesser litigation, logically the foreign direct investment in India will also increase. That's the rationale of coming out with this policy. So if you see, the paper is also titled is Enhancing Tax Certainty in Permanent Establishment and Profit Attribution. So that's the rationale with which the government came out with this paper. If we go to the next slide, what this paper practically laid down is, and what the government's, Som, if you can move to the next slide as well, that they want that there should be clear certainty for the foreign company. What they are recommending are twofold. That today the APA mechanism, the slide earlier than that, so two mechanisms. The slide on of APA, today there's APA is only for transfer pricing, but when you go for a P attribution, generally that's taken up with the APA authority. So they are recommending that as well on the APA to be included in the APA attribution. In case somebody admits a PE, then attribution should also be decided in an APA. They are also to see that if we can get in the MAP cases as well. They're also planning to think, can we come out with a presumptive taxation? This presumptive taxation concept is not new in India. That was there for various foreign companies investing into power sector, oil and gas sector, where typically they will assume that this much percentage. So for example, in those states, 10% of the income was or the receipts were treated as income. On that you pay 40% tax. That means effectively 4% tax, and that's it. You don't need to do anything, and that's good. So that's what they're planning to bring in. That they may also bring in for a safe harbor for P determination and of presumptive tax, depending on each industry where you are functioning, because they cannot come out with a single rate, because margins and the business models of each industry are very, very different. So they need to come out with a different rate. They also intend to clarify, because a lot of litigation comes in, whether the US LLCs, which are fiscally transparent, whether they are eligible for the treaty benefit or not. So they intend to come out with that and clarification as well. Hopefully, what we believe these changes will be carried out in India every year. The budget proposals are announced on 1st February. This paper has come out almost a month, 1.5 months back. So we believe now, the government already has the recommendation of their own arm and body. Hopefully, some of this we can see when the legislation or the amendments are out on 1st of February, and then we'll have to see what form and shape this carries on. Right now, the government is certainly collating various representations on this matter. If you just go to the next slide, the government has come out, and this is what the policy or the body has recommended to the government, that depending on the industry, what should be the profit rates. So if you are in an EPC company, they're saying that 10% will be your profits. On that, you pay now 38% plus surcharge and cess. So basically 3.8% plus surcharge and cess, almost 4% you pay. And then that's good enough. If you are in a supply company or supplying of equipment, then you pay 5%. If you're on a marketing distribution, you pay 15%. The points to ponder are 2-3 things. One, whether these rates align with the arm's length principles, and possibly these rates are on a little bit on a higher side, and maybe representations will be made to make it lower, because today there are case laws which to say that offshore supply should not be taxed at all. But is that you by paying 5%, it's like, you're avoiding litigation, but you're getting peace of mind? Possibly if the rates are a little bit lower, the company may opt for it. Similarly, for other things also like marketing and distribution, 15% on gross rate too seems to be a little bit higher. That is why the representations will be made right now to the government to reduce these rates. And if that happens, it will be a win-win situation for both the companies as well as the government. Another thing which the government will also look at it is this rates the rate will be decided under the domestic law. They will have to ensure that this gets part of the treaty as well, because otherwise the foreign company will not get credit in their home country. And that is why there will be some mechanism which they need to find out, so that they also get the credit in their respective home countries as well. So maybe the government is putting their efforts to see if this subjectivity on P and the litigation on P gets reduced to a great extent. And that is why let's hope this gets passed with certainly some reduced rates, so that it's a win-win situation both for the government and the industry. It's a wait and watch situation so far. This is, as I said, this is still draft, and we'll have to wait until the government comes out on the 1st of February. The concluding.
All right. Thanks, Jimit, Manmeet, and Sanidhi. Thanks, Jimit, Manmeet, and Sanidhi. This brings us to the close of today's discussion. As a concluding thought, I would emphasize that the Hyatt judgment represents a pivotal turning point in India's international tax landscape. For those of you on this call, now is the time to revisit cross-border models, fee structures, and arrangements, particularly where profit sharing and operational, i.e., day-to-day control, extend beyond. Particularly where profit sharing, operational control extend beyond the boundaries of a typical advisory relationship into the realm of active business participation. As a result, it is essential to look beyond the surface and examine the true commercial substance of these cross-border arrangements. With this, we have a few questions from our audience. I'll just, Jimit, first reach out to you. And the question is, will this ruling of Hyatt can increase the chances of retrospective scrutiny? Jimit.
This lays down the land as on today. Hello. This judgment lays down the law of the land as on today. So any open assessments, any open matters before any of the body, whether it's CIT approved tribunal assessment, the department is bound to follow this decision, and they will, because this is the law of the land as on today. So all the open cases before any of the authorities, the tax department will rely on this decision and take the decision.
All right. Thanks, Jimit. There's another interesting question. Maybe, Manmeet, if I can bring you in, rather, there are two parts to the same question. First is, what are the options available to taxpayers for mitigating exposure relating to attribution-related risk? And second part is, can APA provide certainty in relation to the attribution?
Sure. Thanks, Maneet. Very, very pertinent question. So on the first part, what are the key step or mitigation measures? I mean, some of the clients we're working with are very specifically focusing on the deep reviews of the functional overview of their India operations and making sure that the whole of the functional aspects are actually covered in the documentation. We have also seen clients increasingly revisiting the whole of their functional overviews within a say period of every 2 to 3 years, given the Indian organizations are growing very quickly, the role and responsibilities are changing very quickly. So these are very important elements, and which we also noted we need from the poll question result, that almost more than 60% people are either revisiting the attribution exercise or they are thinking about doing it, which is the right way to look at it. Now, second, on the APA program, as you're aware, I mean, uh, in case of a PE, one can go for the APA program, but that would require admission of the PE existence, which differs a lot of people in reviewing whether they are sure of PE being there, PE to be admitted, etc. Now, one where there is an admitted PE, it surely makes sense to actually reach out and take the benefit of the APA program. We've also seen some of the companies looking at APA for their Indian operations and making sure that it captures all of the functional overview that can be attributed to the Indian, say, territory, to make sure that they already have the result being agreed. On since you mentioned there has been judicial precedences also that where for the Indian enterprise, I mean, in case of PA litigation, the reliance has been placed on the APA of the Indian enterprise to say that no further attribution can be done. So these are some of the measures I think the clients can pursue, and we have been working with several of us proactively.
Thank you, Manmeet. That unfortunately is all we have time for. So thank you again, Jimit, Manmeet, and Sanidhi. And special thanks to all of you who were able to join us. We would like to encourage you to fill out the short survey that will pop up on your screen and tell us what do you think about today's program. If you joined us late, please note that this presentation will be archived for future viewing. If you feel that others would benefit from this webcast, please share the webcast via the share this icon or have them visit the Debrief website. We will respond to all the questions submitted during the webcast in next 1 to 2 weeks. Also, if you think of any other questions or comments later, please feel free to reach out to me or any of our speakers. We will be more than happy to talk to you. At last, from all of us at Deloitte, thank you for your participation in Deloitte's Asia Pacific Tax webcast today. Goodbye. Have a great day.